Judge, if you look at the docket sheet, it was reset for to give him time to hire Mr. Rife Kimler.
Yeah.
And
Yeah. How about that? Rice Kimler.
he's telling me
He
that
wasn't here Monday on trial docket.
well, he told me
Yeah, well, he can go hire anybody he wants, but this was something that you told me last time. You gonna hire somebody else or not?
when you speak to him.
We're gonna move forward one way or the other because this thing was indicted back in July. We gotta move forward on it. You can hire anybody you want. He's hired to represent you. I'm not gonna wait around. We're gonna move forward. But you can hire somebody, but I'm not gonna wait for you. It's an announcement. What do you want to do? You're the lawyer now unless something happens. But until that happens, you're still the lawyer. And it's an announcement.
What I would do, Judge, is I was gonna actually give him Rife one more try, but if not, I'll just keep the case as though it's mine totally. And
What do you? Yeah, that's the way to. Yeah, unless until something else happens, you're the lawyer. But we're moving forward. I can't wait. I'm not waiting. It's the way it is. We just move forward.
No,
what do you want to do today? It's an announcement.
Can you give us one last and final announcement and no more, and then I'll just go from there. And if he doesn't want the plea, I'll go to trial. I'll take it.
There is an offer, Judge. I just don't think they've talked about it.
I said,
well, it's a time offer.
Oh.
It's not a probation. He's got priors.
Well, let's see. It's a state jail felony. State jail felony conviction.
2 years.
March of 23.
That's what I see.
March of 23.
Wait,
March of 23. It looks like it can only be enhanced to a third degree, right? Because these aren't sequential. It's all looks like. Well, in March, he picked up 3 convictions in Orange County at one time in 23.
2 state jails, whether they're sequence or not, is third degree. That's it.
Yeah. So it's a state jail felony, but it's punished as though it were a third degree felony. So you're looking at up to 10 years in prison as though it were a third degree felony. You understand how that works? You have to speak up so she can hear and she can put it on the record that you're responding. Okay. That's a yes. He's nodding. Yes, he's not responding orally.
I'm sorry.
Which you have to do. Yeah. She can't.
Yes, sir.
Yeah, you have to respond orally. That's just the rules. I know you're not happy about it, but you know. You're in a mess. Fix it though. It's fixable. This is fixable. What's this? What's the restitution on this?
Good question.
I don't have any requests from the complainant yet, but
okay, so there's none.
But it says the total of the theft was $11,800.
Did they get their stuff back, Langston? Do you know?
Did they get it back with the police report?
Because there wouldn't be a restitution if they got the stuff.
Trailer was located on the side of a house. And I do not show about the other stuff, but at least the trailer was found.
Yeah.
It's got to be the large amount, right?
Trailer was $1,500. The contents was $6,000.
Oh.
So
carpet and tile.
Yeah, Angela Livingston.
Yes, sir. So it looks like they got the trailer back, but I don't know about the contents.
You know, Langston, if the other stuff was returned, do you know? Anybody know?
Your mom's in part. I know. Yeah.
Looking at this police report, it looks like to me it was. I'm looking on page 8 of the. Here we go.
He says he loaned it out to somebody at the time, but it was an unknown person who he won't talk about, which doesn't help. Was his stuff. but they also have a witness showing him driving. Driving. So,
The only thing I saw is they said that the only thing that was missing from the trailer, Ramirez advised that there was a microwave missing from inside the trailer. So I'm assuming everything else was back. That's why
well, I
I'm reading it
think
right
the
there.
trailer had something it was towing, wasn't it? Mine.
Yeah, there's
This is
said his trailer was $7,000. Inside the trailer was about $6,200 in furniture. Ramirez advised there was a microwave missing from inside the trailer. So I don't know if I guess it was all inside the trailer when they found the trailer. I'll double check. That's Kyle's case. I'll have her double check. She'll be back Monday.
Well, that's if there's a loss, the court needs to get him to pay it back. But he can't pay it back because he's in prison.
Right.
He can only pay it back if
He's on
like
probation.
put him on like regular probation, and maybe that's something you don't want to
Well, it depends.
consider if we can get this
It's
stuff back.
just prior. It's just hard to keep giving them probation just because they owe money. So let's just let's see if it was returned. I don't have a problem with whatever.
I'll find out.
Yes, sir.
We can do that. Just one more announcement then, Judge.
Yeah. Okay. Get it resetting. DeMarcus Jones.
Set it trial.
All right. It will be set for trial. Who's the lawyer on that one? Mr. Ham?
Yes, sir.
Okay. Then it's set for trial.
Yes, sir.
And we're trying to move these a lot faster now. So especially if it involves firearms. So okay. I get put on the trial docket. Thank you. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges, sir, that on or about December 18th, of last year, 2024, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct, discharge of a firearm. Do you understand what you're charged with here, sir?
Yes, sir.
It's almost a year.
Judge.
Uh,
And if you remember correctly, Judge, this is the one where he's also being charged with the family violence from the same incident.
Let me just tell you, I've got 5,000 cases.
You probably don't
If you tell me to remember one, it's going to be hard unless I'm dealing with it immediately.
I understand. This is one, Mr. Ham is the prosecutor on the case, and you had asked us if it was a double jeopardy issue because of the misdemeanor. We agree it's not because the bullet inside the home hit the neighbor's house.
Okay.
That's the reason we'd be asking for 5 years on deferred.
All right. This is a third-degree felony. Do you understand, sir?
Yes, sir.
Which means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on, but not found guilty, placed on deferred or unadjudicated probation. This can be up to 10 years in length. Do you understand what the potential is?
Yes, sir.
The fine would be $500, and there would be terms and conditions of probation, which are normal and customary for the circumstances of this offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty. Guilty. Hold on. Now we're speaking over each other. Go ahead. How do you plead?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will. And because you are guilty,
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence,
No objection.
and without objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment read to you. You've read it. You're agreeing with this length of time.
I don't have any objections, Judge.
You
agree.
are.
Fair enough.
Well, I lost my train of thought there when I was. Mike does that to me. It's some psychological thing he pulls that throws me
And
off.
we can work together.
You're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I'm going to follow this agreement. If nothing further, I will find, sir, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, I am instead going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that you're in this probation order. The probation officer will go over them with you. Please follow those. If you fail, your probation can be revoked. Then you could be found guilty and sentenced up to 10 years in prison. So you got to be careful. And these 90% of these conditions of probation are what your lawyer and I have to do. Follow it, like don't commit a crime, obey the rules, you know, the kinds of things that we all should do. And those are good things to be mindful of. You have more to lose than we do, though, if you fail. So get with the probation office, sign those, and you can begin probation.
Thank you, Judge. Sir.
You're very welcome.
Be dismissed.
Yes,
Thank you.
You're Mr. Jones. With Mr. Galmore, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in sum?
He does with me, Your Honor.
In summary, this indictment alleges that on or about December 6th, 2024, in Jefferson County, Texas, you committed the state jail felony of injury to a child. Do you understand what you're charged with here?
Yes, I do.
Okay. It's a state jail felony, which means if convicted, you face no less than 180 days up to 2 years in state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable for this type of offense?
Yes, I do.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated. Is that a 5?
Yes.
I'm going to make it a 5 that I recognize. Placed on deferred or unadjudicated probation, $500, and there will be terms and conditions of probation, which are normal and customary. What is this? 55A. Is that the Texas Code of Criminal Procedure?
It is, Your Honor.
Okay. And summarize. Help me out.
That agreement states that if he completes his probation successfully and does not have any revocations, then the state of Texas will not object to him getting an expunction. It'll still be discretionary with the judge, but we just won't object to it.
All right. Is all this your understanding of the agreement, sir?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes,
That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
We'll waive, Your Honor.
I will follow this agreement, and I will find that you are mentally competent to enter your guilty plea. It's freely and voluntarily made in this case. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt instead and place you on deferred or unadjudicated probation. for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you review them and understand them fully, as you're going to meet with the probation officer. If you fail, your probation could be revoked. You could be then found guilty and sentenced up to 2 years in the state jail, and it's a felony conviction, which would be final, which follows you around the rest of your life. So that's, avoid that. One of the conditions of probation, a parenting class is going to be ordered that helps. That's a good thing. Everybody ought to take it, really, as a parent. It helps remind you of the important things about children being first and the importance of their well-being and how you are responsible for making them the most successful they can be. And that helps you be a good parent. Good luck. Please see the probation officer, okay? Thank you.